We've all been there, right? You're scrolling online and you see a review, a comment, or a post that is just savage. It can literally make or break a business overnight. But what happens when that takedown isn't just an opinion? What if it's a flat-out lie? Well, that's when we enter the world of defamation law, and we're about to break it all down. So think about it. Can one single nasty online review actually tank a whole business? We see these one-star rants all the time, and you have to wonder, wait, can they really say that? And the answer is, well, it's complicated. It all boils down to the very specific legal concept of defamation. So what is it exactly? Defamation isn't just someone being mean or having a bad take. Legally speaking, it has to be a false statement that's presented like it's a known fact, and, this is key, it has to actually cause real damage to someone's reputation. But, and this is a big but, you can't just go to court because someone said something nasty and untrue. To prove defamation, the person making the claim has to check off 4 very specific boxes. Think of these 4 things as the ultimate checklist. If you want to build a defamation case, you have to prove every single one. You need a defamatory statement, it has to be about you, it had to be published, and it must have caused you actual harm. Now, to see how this all works in the real world, let's follow a little story. Let's call it Alex the Talented Baker versus a food blogger who posted a really damaging review. We're going to see if the blogger's claims can stand up to our 4-point checklist. All right, let's kick things off with element number 1. What actually makes a statement defamatory in the eyes of the law? Okay, so there are 3 things that have to happen here. The statement has to sound like a fact, not just someone's opinion. It has to be something you can prove is false. And, of course, it has to be the kind of statement that would genuinely hurt someone's reputation. Now, this is a perfect example. See, the blogger isn't just saying, I didn't like the croissant. No, they're making a very specific, factual claim about the ingredients. And for a baker like Alex, a claim like that could be absolutely devastating to their reputation. And this right here is the crucial difference between a fact and an opinion. Saying something is made with margarine is a statement of fact. Alex can literally pull out receipts from their butter supplier to prove it's false. But saying these are the worst croissants in town, that's just an opinion. And as much as it might sting, you can't sue someone for having an opinion. Okay, so Alex has a false statement of fact. Check. What's next on our list? Well, the statement has to be clearly about the person suing. In this case, Alex. This one might sound a little obvious, but it's super important. A vague comment like, some bakeries around here use fake ingredients is not going to fly. The statement has to point the finger clearly enough that any reasonable person would know exactly who's being talked about. In our story, this one's a slam dunk for Alex. The blogger didn't beat around the bush. They specifically named Alex's Bakery. There's absolutely no confusion about who the target of that review was. So that's checkbox number 2, ticked. On to our third element, publication. Now, when you hear that word, you probably think of books or magazines, right? But in defamation law, the meaning is actually way, way broader. Get this, publication just means that the statement was shared with at least one other person. That's it. It could be a whisper to a friend, a group text, an email, and yes, of course, a social media post. As long as someone other than the person being talked about saw it or heard it, it's considered published. So, for Alex, this is another easy one. The blogger posted that review on a public blog for the whole world to see. That is a textbook definition of publication. We are now 3 for 3 on our checklist. And that brings us to the final, and, often the trickiest element to prove, showing that the statement actually caused real, measurable harm. And this is so important. Just having your feelings hurt isn't enough for a defamation case. You have to be able to show actual, tangible damages. We're talking about lost business, lost revenue, damage to your professional reputation, or even proven emotional distress. This is where the rubber really meets the road for Alex. Imagine Alex can pull up sales records showing a 30% drop in business the week after that blog post went live. And then, on top of that, show emails from customers saying, hey, I'm not coming back because I heard you use margarine. Now that is powerful, concrete evidence of real-world damage. So we've walked through the whole thing, piece by piece. Now let's just put it all together one more time and recap that essential defamation checklist that Alex would need to build a winning case. Okay, let's lock these 4 steps in. Number 1, a false statement of fact that hurts a reputation. Number 2, it has to be clearly about the plaintiff. Number 3,
It's got to be published to a third party. And number 4, it must have caused actual provable damages. And here is probably the most important takeaway of all. You have to prove all 4 of these things. If you miss even one, the entire case can just fall apart. It's a really high bar to clear, and it's set that way for a reason, to try and strike that delicate balance between protecting people's reputations and protecting our right to free speech.
Which really brings us to the big question of our digital age, doesn't it? In a world where anyone can say anything to everyone in an instant, where do we draw that line between free speech and real unprotected harm? The law gives us a framework, but it's something we all have to think about every time we hit post. So what do you think? Where should that line be drawn?